I'm still here.
Okay. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. We have 5 cases on our hearing list today. The first 2 cases we will be hearing on this Zoom platform with simultaneous stream to YouTube. The first case on our list for hearing is a criminal matter, case 2021 P586, Caldwell versus PEDRO, MONTROND. And I have advised counsel that we are familiar with the arguments that they made in their briefs, the procedural and factual background. You needn't go through all of that. We will have questions for you and 15 minutes per side and no rebuttal. Attorney Smith, you may begin. You're going to need to unmute yourself, Attorney Smith.
Good morning.
Good morning.
May it please the court, my name is Andrew Smith and I represent Mr. Montrond. I'd first like to start by thanking both the panel and the Commonwealth for allowing me to appear by Zoom. It means a lot to me to be able to represent my client from beginning to end, so thank you. Today I'm asking this court to overturn Mr. Montrond's convictions and to return his case to the trial court of Suffolk Superior Court for a new trial. First, because the trial court refused over objection to inquire of the jury pool whether they may have a bias for or against child witnesses. And second, because the Commonwealth's closing exceeded the bounds of permissible advocacy. I'll first discuss the first issue of the brief, which in fact involved a very simple and reasonable request. The defense counsel asked if, in fact, with the agreement of the Commonwealth, whether the judge would inquire of the pool whether they had bias for or against a child witness. This was both reasonable and simple because it's already part of our system that we recognize that child witnesses are a special category of witness. In fact,
let me interrupt for just a moment and ask you a question. Let's say, even for example, hypothetically, if we were to agree with you that it might have been better to ask the question that was posed to the judge by both the Commonwealth and trial counsel. But where in the record is there any support for a conclusion that any juror that was actually biased was seated? In other words, the judge asked all of the jurors whether or not they had any bias or prejudice. Some of them responded affirmatively to that question. They were all subject to voir dire examination by the judge, and all of them were excused.
Well, I think it's, I would, again, I believe this draws a similar parallel to cases where police witnesses are central to the prosecution. It draws out and draws focus to a potential class or a potential bias of the jury that a juror may not consider with a general request that do you have any bias about this kind of case. In fact,
except that in this case, the jury was informed beforehand that we were talking about an alleged victim that was a child.
And the usual individual voir dire that would follow up to that is not about their view of a child witness, but about whether they know or had been a victim of sexual abuse before. So, and again,
Mr. Smith, if I could just get a foundational question out. Are you contending that there was a categorical requirement to ask this question, so the judge's refusal to ask the question was an error of law, or are we reviewing here for abuse of discretion?
I think by the law, we're asking for it's under abuse of discretion. I would certainly not hesitate to push for a more categorical or at least a de minimis requirement that the question be asked. Again, much like the police question.
I agree with your answer. I do understand the law to be that this would be committed to the judge's sound discretion, that the decision not to do it not in and of itself represent a clear error of law.
And it's unclear. I mean, certainly I would have preferred, and I think the panel would have preferred the judge be a little more verbose about why his rebuke is very immediate and sharp, as if the question is almost a taboo, where leaving us on the record, we don't really have any sense of why he was in some ways very sharply opposed to the question.
Mr. Smith, can I ask you on that? Is there any? It was a she, but to the extent that she decided not to ask the question, am I wrong?
I'm sorry, you broke up a little bit. Can you repeat?
I'm sorry. Yep. So to the extent the judge decided not to ask the question, does her reason for not doing so matter at all?
In abuse of discretion, I believe so. Yes.
Okay.
And that's certainly if you look up my name in the appeals court docket, I've handled many sex cases,
right.
And I've waited for many years for a case where this child witness issue comes up in voir dire, much like I've waited for it to come up in jury instructions as well, because I do believe that one of the obstacles that a defendant faces in these types of cases may very well be a bias of the jury. So certainly when it came up in this case, where it's objected to, it's requested with Commonwealth assent. This certainly posed an opportunity to raise it just
So
to get the court's position on this.
Can I follow up? So you agree then that if we follow what you're asking us to, we're essentially making new law in that area?
I don't want to toot my own horn, but yes, I hope we are. Yes.
Is it your position then that that needs to be asked as part of the individual voir dire, or would you be satisfied if it were put to the general venire?
I believe the values to the general.
Okay.
The Commonwealth raises a good point about that, and I'm not sure I have a great answer other than there is value strategically to asking the general voir dire, and I'm deferring to the trial attorney's tactics about not following into the individual voir dire, though I think it would not have been unreasonable for the trial attorney to, after the rebuke he received, asking for the general to not pursue it in the individual. And certainly the language of the court says something about you can do individual voir dire in response to answers from the juror. Which,
in fairness, Mr. Smith, it seems to me that if trial counsel had an interest in exploring that as part of the attorney questioning during voir dire, would not have been unavailable to at least ask for clarification, not to hazard unilaterally to pursue that line of questioning.
I agree with you. The record certainly would have been better for us if this had been continued at individual voir dire.
There's nothing on the record that flatly precluded that pursuit.
Other than ambiguous language from the court saying you can ask in response to an answer.
Yeah, but
I'm not sure what to make of that as well.
That language was sufficiently unclear that at a minimum, if counsel had wished to pursue that, it would have been open to them to ask for clarification on that topic.
Yes, but I think it's not unreasonable after a rebuke. You don't push too many times because you may need something from the trial court later.
But counsel,
yes,
what would have
agree.
been the point? What would have been the point here? Every juror that indicated that he or she had a potential bias or prejudice was immediately excused by the judge. There wasn't any follow-up questions on any of those individuals, because from my reading of the record. A number 1, 2, 3, 4, 5, 6, 7, 8, about 9 or 10 on day one indicated that they responded affirmatively to the judge's question about bias or prejudice, and every single one of them was excused. And the same thing happened on day 2.
And again, going back to the parallel, I've had any number of, as a trial attorney, cases where there's a general question about bias, and lo and behold, if the court asks about bias concerning police testimony, not surprisingly, you'll get hands up that
more so than you would just for the general question. My point was is that in terms of the follow-up questions during individual voir dire, there wasn't really an opportunity or a need to do it because all of those particular jurors were excused.
That's correct.
No.
I think that's what I was trying to say earlier. There was no opportunity. There was no invitation to reflect on the biases of the jury pool regarding child witnesses during individual voir dire, so the question didn't come up.
Do you want to move to the closing argument concerns?
And the second issue before us is the question of, did the Commonwealth's closing exceed the bounds of permissible advocacy? It does seem that the Commonwealth is dancing on any number of different lines here. The repeated claims that the witness was credible, as was her mother, no reason to lie, the exclusivity of the sexual knowledge, the evocation of sympathy regarding her age, should have been a first kiss rather than a rape, and the final issue being the invitation to speculate regarding why would they pin this on Mr. Montrond when they already had a potential predator that she admitted to when the mother was questioning her. But again, are any of them over the top blatant? Well, we know the Commonwealth makes these arguments and uses this terminology over and over again. This is a closing that seems to invite us to wonder whether there's enough dancing on lines here to warrant bolder action than simply saying it's permissible advocacy and moving on. I'm sorry, I can't see my time. I believe I'm running out of time, so I believe I will rest on the brief unless anyone on the panel has any questions about either of the issues.
Seeing none, thank you for your argument. We'll hear from the Commonwealth.
Thank you.
May proceed, Mr. Doherty.
Thank you, Your Honor. May it please the court, Andrew Doherty for the Commonwealth. I'm asking that the court affirm the defendant's conviction. I want to point out a couple things. Judge Vuono, you mentioned the 8 jurors who answered yes. I cannot stand unbiased in this case, but every one of those jurors also answered yes. I cannot stand indifferent based off of the facts that they heard. I think that's important because the jurors heard this was an 11 or 12-year-old victim, or the sexual assaults occurred between the ages of 11 and 12, and then heard a description of the acts that were being charged, and really that was it. And so I think if you look at it with this lens, the judge was right when she makes this statement we're going to get a number, sort of predicts we're going to get a number of jurors that are going to stand indifferent as it is. And with that in mind, I think it was reasonable for the judge to say essentially that we've asked enough questions about this with the bias and indifference. The only other thing I would add there
Really,
is,
you think it was I think you said a reasonable decision not to ask one additional question to the veneer after both the Commonwealth and the defense agreed that this would be a good question to be asked?
I do. I mean, if you look in some, nearly half of the jurors in the first day said they couldn't be unbiased or indifferent about this very issue.
Those responses came in response to different questions, and you do recognize that there is a slightly different question being raised when the question is asked about the credibility of the child witness.
I don't disagree with that it's a more specific question. But I would also add in context that the child victim, though she was 11 or 12 years old when the attacks occurred, was 16 at the time that she testified. So I think, were she 11 or 12 years old, that question may, while she was testifying, that question may have more importance in a case. But when she's 16, she's not even she's a middle-aged teenager, right? And so for this question, do you believe a 16-year-old when she testifies is different than asking, do you believe an 11 or 12-year-old when she testifies? So I think there is some nuance there that's also before the court when she's making this decision. The only other thing I would add is this was a jury that came back with one acquittal, one inability to make a finding, and then one conviction on the case. So the fact that they came back split shows that they were carefully reviewing the evidence. So
what you're getting at is the question I actually posed to your brother in the very beginning, which is even if we were to conclude, again hypothetically, that this question should have been asked, you're saying that there really was no showing of prejudice on the record because the jury was declared to be unbiased and there was no objection and there was a split verdict. But going back to your brother's point, even if, what in the future should this question be asked or not be asked in your view?
I think it should be decided on a case-by-case basis for the very reasons that are that it's a 16-year-old child, right? It's a 16-year-old that's testifying, right? And to find that you have to ask this question when they're 16 or 18 or 20, but for the fact that they were a child when the victimization occurred, I think there's too much room there and that's the kind of thing we do leave for a trial judge's discretion to assess the entirety of the issue.
Can I ask Mr. Doherty on that point, if I may? Have you finished your answer to that? I'm sorry.
I have. Thank you.
I'm looking at volume 1, page 52 of the transcript, where the judge's reason is we have a lot of people who are going to be heard on that. The number of people that can't be impartial, so I'm not permitting that. So if the reason is you have too many people who might raise their hands, is that a good reason not to ask a question, or is it the opposite? It just
no. I take the judge's point, but I read that her sort of, I don't want to call it a ruling, but that explanation a little bit of a different way than you do, Judge Brennan. I think when she's talking about impartial, that was the answer that nearly half of the jury raised their hands to, right? That already we were going to have problems with partiality here. So to then drill down on this one particular issue, it seemed that it would, my guess is the people who were answering the impartial question, yes, would have also answered, yeah, I have a problem because it's a child, and
you're taking that as not, we got to get through this impanelment and too many people are going to raise their hands, but that's already covered by what we've already asked.
Correct.
Okay. Correct.
And I would just point out there were a few follow-up questions with some of the jurors who answered impartial. That's sort of the number I was looking at. And all the ones who did explain were either teachers or fathers of daughters. And so you can see where they were having a problem with this case. And I think that the judge was within her discretion to make that decision. I take the judge's point where both parties are agreeing, this is a question that could be asked, or at least the Commonwealth isn't objecting. I mean, if you see that the evolution of this question, it goes from, do you have a predisposition to believe child accusers, to then, do you have a tendency to believe child testimony, being the sort of final question that was asked. Even with that evolution, where it's a 16-year-old who's testifying, it seems like it's far less important than it once was.
So in your view, we shouldn't be harboring a concern that the judge was motivated to deny the request out of fear that it would be even harder to impanel a jury out of that pool?
I don't, that's not how I read her response at the very end. It was that we've already essentially asked that question. We're going to have a number of people who are going to say impartial, and Justice Fahey, has done a lot of these, and I expect she knew exactly how the jurors were going to respond when they heard these facts. And she was right. There were 24 on the first day who said they couldn't be impartial. And I do think both the bias question and the impartial question speak to the issue that's raised by this question, which is there's going to be a child testifying about what happened. Does that bother you? And in that respect, both that question was answered, or was asked with the bias and impartiality question.
Doherty, if we read the question, or the court's explanation differently than you do, and again, as simply, well, we've got a lot of people going to raise their hands, and we've got to get a jury here, so I'm not asking that. Is that an abuse of discretion?
I would say no, in first part, because they've already, she's predicting there's already going to be a bunch of people who raise their hands. She predicts that correctly, and so this question is superfluous, or the other word, and then alternatively, she still left room for the defendant, the trial counsel, to ask these questions, or the jury, or at least we don't know whether she would have pushed back on that. And you don't see, the only time you see the judge push back on an individual voir dire question is when trial counsel starts asking about a juror who was on a previous panel. And even then, it wasn't particularly contentious. She just put some boundaries on there. So we don't know whether this was something she was going to refuse, because it was never asked. Moving to the closing argument, I think that the one part that's maybe a little confusing is the Beaudry issue raised when trial counsel, the prosecutor argues, she should have been, this was something new to her. This sort of innocence thing that is raised in Beaudry, where you can't say her basis of knowledge about sexual activity comes from this defendant. And I think that the prosecutor's argument was much more nuanced than that, where there was real confusion from the witness testified. She was confused about whether this was anal penetration or vaginal penetration. And that is not uncommon with child victims. And Justice Green, you may recall the last argument we had, the same scenario came up where the victim was confused about whether it was anal or vaginal penetration. And so it was a reasonable thing for the ADA to address that and attribute that to just her inexperience. And I think that distinguishes it from Beaudry enough to do so. And unless there's any other questions, I would otherwise rest on my brief.
Seeing none, that will conclude the argument in this case. The case is submitted. Thank you both for your argument.
Thank you.
And just for the record, I have absolutely no.
All right, we're live.
The next case on our list for hearing, also on the Zoom video platform, is case number 2021 P862, the Canola versus Benedict DIEUJUSTE. Mr. Gauthier for the defendant.
Good morning, Chief Justice and members of the panel. May it please the court. For the record, my name is Edward Gauthier. It is my honor and privilege to argue today on behalf of my client, the defendant appellant Benedict DIEUJUSTE. In this case, a district court jury convicted my client of assault and battery with a dangerous weapon, to wit, a drinking glass. My client's defense at trial was self-defense. So the sole issue at trial was whether the Commonwealth could prove beyond a reasonable doubt that my client did not act in self-defense. On appeal, we are arguing two issues. We're asking the court to set aside my client's conviction and remand the case for an order granting her in a new trial. In the alternative, we're asking this court to remand the case for an evidentiary hearing. I'd like to start with the second issue, which is the request for an evidentiary hearing. In this case, trial counsel filed with the court an affidavit supporting the defendant's motion for a new trial. And in it, she acknowledges that she made errors. Nonetheless, without hearing her testimony, the trial court decided that her decision to introduce the medical records that are at issue in this case was a strategic decision. This is in spite of the fact that the court, the trial counsel, and the Commonwealth all agree that it was an error, that it was an oversight, a mistake of some kind, for trial counsel to allow in the words, "the patient's attacker has been charged with assault and is in prison," on record appendix 15. And this is a 4-page medical record. I know that we have some cases with hundreds of pages of medical records, and sometimes a line here or there in the medical records may slip through, but this was a 4-page medical record, and the court in its oral findings acknowledges that this should not have come in, and then decides that, well, it was a strategic decision to allow in the medical record. And I'd like to argue a little bit why the finding that this was a strategic decision was an abuse of discretion.
Well, you got 2 points there, Mr. Gauthier. The first is that that on the record that we have, that was an incorrect determination. And the second is that the failure to conduct an evidentiary hearing deprived the court of meaningful evidence that it should have obtained before making that determination. Why don't we start with the second of those first? And it seems to me that to the extent the trial counsel wanted and motion counsel wanted to negate that question, it would have been an easy thing to do. Everyone knows what the standard is, everybody knows what the rules are, and it's not that hard to include a statement. In fact, I've seen it quite frequently in my own experience, for the affidavit to disclaim any reliance on strategic considerations. The absence of that was fully within control of the affiant and the motion counsel. And I think the judge is entitled to take that into account and make the decision about what more would be gained by an evidentiary hearing.
Well, there is some that would be gained by an evidentiary hearing in this case. In this case, trial counsel, in her several paragraph affidavit, especially in paragraphs 4, 5, and 6, notes that she should have done different things. Regarding the strategy, the judge in this case finds that it was a strategic decision to question the victim in this case based on prior inconsistent statements. And in this case, defense counsel exhausted essentially all of her ammunition at this trial, portraying the victim in this case as a person who lacks credibility. And the judge in his findings spends some time detailing all of the prior inconsistent statements. But as the Commonwealth states at page 39 of the Rule 30 transcript, that this case is not about credibility. this case is about video and whether the video establishes beyond a reasonable doubt that the defendant, my client, did not act in self-defense. So the judge finds that it was a strategic decision, that it was not a manifestly unreasonable strategic decision to use these medical records. But it begs the question, if there's a video, and there is a video that this court has the opportunity to watch, what exactly was the strategic value of establishing that the victim in this case made prior misstatements?
Well, if there were no need by virtue of the video for witness testimony at all, then the witness would not have taken the stand. Once the witness takes the stand and is demonstrated to have given one version of events before she was confronted with the video, and then changed her story to conform to the video, it seems to me that there is some strategic value for the defense undermine the credibility of the victim on that basis.
Well, during her direct testimony, the victim in this case was confronted with the video. And prior to the discovery of the video, the victim made these prior inconsistent statements. But at trial, during her direct testimony with the Commonwealth's questioning, they played the video and she acknowledged that she swung first. Her prior inconsistent statements were that she did not swing first. So she was fully impeached she was fully put before the jury. The victim swung first, the defendant reacted, and you'll see in the video, in a split second with her hand and smashed her in the face with the glass. It's not just that defense counsel used prior inconsistent statements. It's essentially largely the entire case. The victim is a person who has made prior inconsistent statements. The issue in this case is at that second, and it's 1 second, at that 1 second, was the defendant exercising self-defense? That's the sole issue.
I understand that, but for the question for the jury and the question for the defense is whether the revelation, just making the advocate's argument here, was the revelation that the victim was someone who cannot be trusted. Does that bear at all in their interpretation of events as narrated by the victim on the question of self-defense?
If this was evidence under case law that allows a prior act of violence to come in, yes. But an individual's, the reasonable use of force in self-defense doesn't, in my mind, depend on whether the person being hit or attacked or struck is an honest person, is worthy of belief.
Mr. Gauthier, if I can ask, sorry.
The more emphatically you make that argument, Mr. Gauthier, the more I'm hard pressed to identify prejudice, because the video establishes conclusively that there was no credible claim of self-defense, and the testimony didn't matter, and the credibility of the victim didn't matter. And, it's hard for me to understand how any of this would have been exculpatory or prejudicial, because the victim does it all.
Well, it's prejudicial because this is a case where, and if you watch the video, it's two women in each other's faces. One takes a swing, one immediately responds. I note that the court's going to see some action in the video after the glass. My client's been charged with assault and battery with a dangerous weapon for the glass to the face. And I can tell the court, the court can infer that my client was charged based on the complaint immediately after this happened with assault and battery, dangerous weapon. All of the things my client does on the video, those things were discovered after the video was discovered by the Commonwealth. They didn't charge her with the conduct after the glass. So I think I don't think we can say that the evidence on that point regarding self-defense is clearly conclusively borne out with the video. The video shows...
Just to follow up on Chief Justice Green's question, if we take your argument to its logical extension, it seems to me that, and I agree with you, we have a video. The jury had a video that depicted the events. Doesn't that undercut your argument, though, with respect to whether asking a few leading questions made a difference, or the victim saying beyond reasonable doubt that she hit me first, or whatever? I'm paraphrasing. If the jury has it right there to see for themselves, what impact could that have possibly had, as you've just indicated.
Well, Your Honor, putting aside the beyond a reasonable doubt and putting aside the leading questions, the medical records indicate that there is a diagnosis. So in the court's oral decision, the court says that the medical record does not indicate that the victim was assaulted. It only indicates the victim says she was assaulted. But on Record Appendix 14, they diagnose her with assault. Assault is a legal term. It says she was assaulted, diagnosed with assault, says that the patient's attacker was in prison. This is a case where the court acknowledges in its findings that we have two women who obviously have a history with each other, and both gave testimony that was not entirely consistent with the video. And this was an extremely close case. Watching the video, looking at what my client was actually charged with, she reacts in an instant to the punch. And now we have a medical record declaring that the victim was assaulted. And as a result, the client is in prison. I think,
again, but just if you can answer the question I asked, I think you've argued, or you argue that the judge's denial of the motion for new trial based on his assessment of the effectiveness or ineffectiveness of the attorney. There are a number of different reasons, but if I follow your argument again that you're making now, the jury could watch the video, just as you did, just as the attorney did, just as we did. And these other, if you will, discrepancies don't really make a whole lot of difference. So how do you show the prejudice? Putting aside the medical record in the prison part.
Well, the video is imperfect, I would argue, that as the Chief Justice said, if all they need to see is a video, why did anybody have to testify at all? They had to testify to put forward the narrative of what happened. Not everything's on video. In terms of a self-defense claim, what matters is the reasonableness of my client's conduct in the context of where she was, knowing what she knows. So she has a background with the victim in this case, her view of physically where she was, the circumstances, the emotions she may have had. These are all relevant. So I don't think you can say, yes, the jury could just look at a video like this in these circumstances and say, we don't need to hear anything, and say, we can find beyond a reasonable doubt that the defendant did not act in self-defense, simply looking at the video in this context. It happened far too quickly to really, for a jury to find beyond a reasonable doubt lack of self-defense. So yes, testimony was necessary. If the medical records didn't matter, they wouldn't have come in. If the testimony didn't matter, it wouldn't have come in. So the question of prejudice is, we presume that they have the medical records. They're only 4 pages. We presume that they looked at them. And what we have is we have a healthcare provider declaring that the victim in this case was assaulted. And that's pretty significant, especially when you have the competing testimony over exactly what happened.
Just to clarify one point, Attorney Gothier, do I understand that argument to be made only in the context of ineffective assistance of counsel with respect to the motion for new trial? It's not an independent ground for reversal of the conviction, correct?
The argument on appeal in this case is solely the denial of the Rule 30 motion based on ineffective assistance and the denial of the evidentiary hearing, as trial counsel was prepared to testify.
Thank you.
If there are no further questions from the panel at this time, the defendant and I would rest on our brief.
Thank you, Mr. Gauthier.
May it please the court, Darcy Jordan on behalf of Commonwealth, and watching via the live stream is the trial prosecutor, Jessica Frateroli. Commonwealth is asking you to affirm the denial of the defendant's motion for a new trial. The fact that it was done without an evidentiary hearing was totally in the discretion of the judge, and I think the right call in this case. I think a close reading of the affidavit is that the judge credited her affidavit, essentially saying the trial counsel in hindsight might have done some things differently. And I think my brother reads her statement regarding the medical records a little too obtusely. Her statement specifically says, I would have struck or redacted the highly prejudicial statement. And I think that is in reference to the prison statement. So I think saying there's no global statement saying that it was unmanifestly unreasonable or a strategic decision. That's not what she's saying in that statement. So to go back to just to differentiate between the statements of assaults in the medical records and this one statement about prison. So I think her affidavit is just talking about prison. I think it's clear that that probably should not have come in. But I think given all the evidence, I don't think it made any difference in this case, and it definitely did not deprive the defendant of a defense, which is the meaningful question.
That it was a strategic decision. How heavily, in your view, does the conclusion on the question of ineffective assistance rest on that determination?
I'm sorry, about the statements about assault in
the judge found that trial counsel made a strategic decision not to redact this material. And if we were to disagree with that, how heavily, in your view, does the judge's finding that no new trial is warranted depend on that ostensibly erroneous?
And I just want to make sure, are you speaking just about the statements about that she was assaulted, or are we talking also about the prison statement in the medical records? Both. So I think those are two different determinations made by the motion judge, the one about the prison statement and the ones about the assault. And I think if it was, assuming it was erroneous, which Commonwealth does not concede, it would not make a difference in this case, because we have a situation where we do have the video, and we also have the statements of the victim, who I think in this case, she was not the most cooperative victim. So I think her credibility in and of itself was before the jury. So I think if we omit this evidence, I think what is left is that the defendant still had wasn't deprived of defense. So that's really what we're looking at. So if we excise those statements and say that was erroneous and should never have come in, what we're kind of left with is statements of the victim's testimony vis-a-vis this video. And I think it doesn't change, that doesn't really change the calculus, because if we recall, this is a self-defense case. So there's a concession. The defendant concedes out of the gate, I struck her. So what really just was that, or was it in, either was it excessive force, or was it not legally justified? So I think we could, my brother obviously takes issue with some of these evidentiary rulings, but what I think it really comes down to is whether or not the jury had the ability to juxtapose the victim's testimony with the video. I don't know if that answers your question, Chief Justice.
Yes, thank you.
And if I could just turn to the prison statement, I think when I went back and really looked at the affidavit and I looked at the instructions given, I think this is analogous to when the judge gave the preliminary instruction that the complaint itself is just a charging document, that the ultimate decision is before the jury. So I think this kind of idea that there's some statement that wasn't highlighted by any of the parties is kind of similar to that. The jury obviously knows that it's here making a decision and the defendant was charged. So I think this, to stress that this somehow prejudiced the defendant, I think when it's actually critically looked at, loses its steam as a reason that this should be conviction should be overturned. I don't see any other questions.
Nor do I. If you have nothing more to say to us,